Hi, welcome back to Frequently Asked Fridays, where we answer your questions about intellectual property matters. Today, the question we're going to answer is, when should I file to protect my intellectual property? There are certain timelines, certain deadlines for patents, for trademarks, and for copyrights that need to be adhered to in order to get the protection down right. So let's talk about patents first. When do I need to file my patent application? A couple dates to keep in mind. One, ideally, you should file that application before you have a public sale or a sale, a public use, or a disclosure of your invention. In the U.S., there's a 1-year grace period for filing your patent application with regard to that date. So at a very minimum, you must file your patent application within 1 year of any public use, any sale, or any public disclosure of your invention. If you don't file within that 1 year, your own invention can be prior art and can bar you from patenting that invention. The other thing to keep in mind is that about 10 years ago, we went from a first to invent to a first to file system in the U.S. So you want to file as soon as possible. Today, tomorrow, immediately is not too soon to file, because if somebody else beats you to the patent office with the same or a very similar invention, they are going to be in line ahead of you to patent that idea. Uh, Many people have heard of what was called a poor man's patent. That was good up until about 10 years ago. That's where you would write your invention down on a piece of paper, put it in an envelope, seal that envelope, stamp that envelope, and mail it to yourself. That way, again, under the old first to invent system, you had evidence of when you invented that, because you have a sealed envelope with a postmark on it that says, as of a date certain, you had invented that. That doesn't matter anymore since it's a first to file, but I thought I'd talk about that just from a historical perspective. Let's move to trademarks. So with trademarks, again, that's you acquire rights in a trademark just by using it, but those rights are limited. They're limited to the geographic area that you are operating in. So I typically advise people file that application as soon as possible, or at least as soon as you have use in interstate commerce, which is something that crosses state lines. I can give you an example. I have had a client come to me recently that's been using a name with regard to a restaurant or shop for several years, I think 5 or 6 years. They happened to be on the internet and looked and saw somebody using the same name with a very similar business. So I looked into it. That other company actually had already filed their application for a federal trademark. So we are now behind them in line. Doesn't necessarily mean we can't jump them in line, but it's going to be much more difficult and much more expensive than it would have been had this client just filed for that trademark 4 or 5 years ago when they started the business, instead of trying to save a little money and defer it until later. Now, uh, it's less certain that they can get the trademark registered, and it's probably going to cost more money. So if you do this early, if you move to register it early, it's usually relatively inexpensive, particularly compared to doing it later on when problems arise. Lastly, with regard to copyrights, again, copyrights, very much like trademark, you acquire rights without registering the copyright. But a couple things there. One, in order to sue somebody for copyright infringement, you have to have that registered first. That's something that can be done fairly easy after the fact. So, if you notice somebody is infringing your copyright, we can then take that uh, and get your copyright registered fairly quickly. Oftentimes that's going to involve an extra fee with the Copyright Office, but that can be done after the fact. The thing you miss out on there by waiting, again, with copyright is you lose out on the possibility of something called statutory damages. Statutory damages are damages that are assessed just based on a dollar amount, regardless of whether you can show actual harm or the amount of actual harm. And it's a big benefit to copyright owners to have that availability of statutory damages. If you don't register your copyright until after the infringement occurs, you're not eligible for statutory damages. So you're losing out there. So again, as with trademarks and with patent, with copyrights, you want to register that as soon as possible, so that you can maximize your protection in that. Hope this has been helpful information to you. We appreciate you tuning in, and have a great weekend. We'll talk to you soon.